Welcome to Basic Black. Some of you are joining us on our broadcast, and others of you are joining us on our digital platforms. I'm Callie Crossley, host of Under the Radar 89.7. Tonight, Harvard admissions and affirmative action. We, like you, are dealing with the effects of the coronavirus pandemic and are taking precautions. We are working with limited staff, and our guests are joining us remotely. The case against Harvard's admission policies, which went to trial in 2018, was always meant to be bigger than Harvard, brought on behalf of Asian students who claimed the way the prestigious university ranked Asian applicants was discriminatory. The plaintiff's remedy? Get rid of affirmative action, a policy the Supreme Court sanctioned, allowing race to be considered as a factor. Not the factor, but a factor. Harvard won its case in 2018, but last month, a new conservative majority Supreme Court agreed to hear a new complaint brought against Harvard and the University of North Carolina at Chapel Hill. Many expect this time the High Court will rule for the plaintiffs. What does that mean for future Asian students of color and for affirmative action? Joining us remotely, Dr. Paul Watanabe, Director, Institute for Asian American Studies and Professor of Political Science, UMass Boston. Dr. Natasha Warriku, Professor of Sociology at Tufts University. Jessica Lewis, a staff attorney for the ACLU of Massachusetts. And Bethany Lee, Senior Attorney and Director of the Asian Outreach Unit at Greater Boston Legal Services. Welcome to all of you. So, we first discussed this case in 2018 when Harvard was actually in the middle of the trial. And Paul, I want to begin flashing back to the conversation we had then when I asked you if the lawsuit was structured in a way to say that Asian American applicants are being disadvantaged. Here's a portion of what you said.
The remedy is to take race as out of the picture, to do colorblind admissions and not consider race as the law allows as a factor in making admissions choices. That I see as a much greater concern, and that's really the objective of this suit. The situation of discrimination against Asian Americans is what I see as a fig leaf to cover off this real purpose of the suit.
So we've now, it's been 4 years, Harvard won that case. Has it been proven to be the fig leaf that you thought it was? And what is your concern at this moment?
Yes, I believe it's not only a fig leaf in this case, but in generally in terms of the right wing sort of fighting against the transformation of American society and becoming a more diverse society as we're seeing it taking place every day in the United States today. There's a resistance to the fact that the United States will soon become a majority non-white country. And part of this polarization and discussion that we're having today is being reflected in discussions about whether race should be a factor in determination of admissions or whether it should be a factor in in voting rights and so forth. And the whole discussion about this is a part of a larger attack upon the notion that the diversity and change that's taking place within the country is something that's good for the country, something that we should try to promote and try to develop, and that the diversity and having representation of a variety of people and races within various sorts of places of power, including places like elite universities like Harvard, is a good thing. That's fundamentally what we want to talk about, what this issue is about. And it's not so much about Asian American students, it's principally about white students and what white students and whether whites are going to get their, as they perceive it, their particular interests served in these various arenas, whether it's education or electoral or voting rights, et cetera.
So Natasha, the remedy, they say, is take race out of it. Let's be race neutral. Please explain, what does that look like and why that hasn't worked?
Well, it's unclear what it, at a very simple level, what it looks like is not asking for race in the application. Now, race comes up in other ways. Sometimes a person's name might signal race. Sometimes they might talk about an experience of racial discrimination or, in their essay. So there are other ways that race will come up, but it literally means, you don't check those boxes. And then the university is not allowed to take into consideration race. Now, the legal the law says, well, you have to make sure that there are no other race neutral alternatives to looking at race. And a lot of social science over the last, decades have shown that there really is no good substitute for race. Because race captures so much in the United States in terms of, not just experiences with racial discrimination. It also includes, the kind of intergenerational impact of residential segregation, of the accumulation of wealth for whites at times of residential segregation. It accounts for so many factors that it's really hard to, and a lot of these things are almost impossible to measure. We don't have good measures of experiences of racial discrimination, of, intergenerational trauma, of, wealth. And so it becomes very hard to substitute a kind of proxies for race when we have something that actually captures all of that, which is race.
And Bethany, it's been demonstrated now with all kinds of studies and research and evidence that affirmative action works. It provides an opportunity. It doesn't give you an opportunity, but it provides an opportunity to be in spaces where it was not possible because of racial discrimination. But I think a lot of people sort of half hearing about the past Harvard case and now this new one that's coming up wonder, well, if the Asian Americans students or Asian students who are persons of color feel strongly enough that Harvard is somehow discriminating against them, what are they seeing? Because it should be noted that there were multiple organizations, including some student Asian organizations, that wrote in support of the Harvard case in 2018 saying this challenge is not that we do not support this challenge to Harvard's admissions policies. So what is at the core of what these plaintiffs are saying?
I mean, the fact that so many students and Asian American people actually have spoken up in favor of affirmative action shows exactly what you're saying, is that it works, that the diversity benefits, that all of the things that you would expect from a multiracial class with a variety of experiences is really what's important. 70% of Asian Americans do support affirmative action. It's a small minority of people in the Asian American community that don't support affirmative action. And it's a bit of a smokescreen, I think, where the questions about whether or not affirmative action using race-conscious admissions is constitutional is a separate question from whether or not Asian Americans are discriminated against. And in the Harvard case, the judge found that after extensive testimony from students, including Asian American students, Vietnamese and Chinese, the judge found that there was no intentional discrimination against Asian American students. And so I think the question of affirmative action and whether race-conscious admissions benefits people is an entirely separate question, because it's obvious that affirmative action benefits everyone, including Asian Americans.
It was a surprise to all of you, Jessica, but you noted that especially surprising with regard to the addition of the University of North Carolina at Chapel Hill was that the case was able to sort of skip a level of court intervention before arriving at the Supreme Court. What does that say to you, and why did they agree to take both a new Harvard challenge and the University of North Carolina case?
That's right. For the UNC case, it's only been heard by a district court, and the Supreme Court took the case without ever giving the Court of Appeals a chance to decide the issue. And generally, when the Supreme Court is granting cert, they are looking at there's some type of split in the circuit. There is some kind of urgency or immediacy to the case. And here, arguably, those issues or those factors were absent. When we're looking at both the UNC case and the Harvard case, specifically the Harvard case deals with discrimination against Asian American students, whereas the UNC case deals with both discrimination against Asian American and white students, which draws into question about whether or not the Harvard case is generally backing or just using Asian American students as kind of a smokescreen for something larger. And importantly, both the district court and the Court of Appeals in the Harvard case noted that if there is some type of discrimination against Asian American students, the remedy for that is to stop discriminating against Asian American students. And part of that might be that there is some type of implicit bias, in which case you do actually need to be considerate or conscious of race in order to address that bias. And the remedy for any type of discrimination is not to strike down affirmative action, is to stop discriminating.
So again, that when the court said race could be considered as a factor, but not the only factor, if in fact any of these universities or colleges, but the Harvard case used race as the factor, that would be unconstitutional. But Harvard claimed, and the court agreed, they did not. They followed the rules and said race is a factor. And in fact, Harvard says they have 4 very strong criteria by which they evaluate each applicant. The top one is academics. There are 3 others. And then after that, then they consider race as a factor. And the point being, just so that we have this on the table for our viewers, is that the court was very clear in how they sanction using race as a factor, Natasha. You could not use it to correct past injustices, which a lot of people say, well, isn't that what we're doing by considering race as a factor in these admissions policies? No. The court said it is valuable as a mission to increase diversity on campus. And the way to do that is to use race as a factor. So please speak to that.
Yeah, I mean, affirmative action in higher education started in the early 1960s, and it really was very explicitly a policy to remedy past discrimination, past racial exclusion. It started in a lot of northern colleges that, didn't explicitly exclude African-American students, but, very few African-American students, if any, went to those colleges, in part because they didn't have the educational opportunities to be able to study at those places. And they recognized that this was wrong. And so that's the historical origins of affirmative action. And then fast forward to the 1978 Bucky versus University of California Supreme Court decision, where there was a split that was related to affirmative action, and the court was split, and Justice Powell said, well, you can consider race if it's one of many factors and it meets the goal of a diverse learning environment. And so that became the sort of legal justification for affirmative action. Now, I think that, in my view, and I'm not a lawyer, so I think I can say this, is that, it's pretty clear that there is a lot of, ongoing racial exclusion. And so, to me, that also argues in favor of affirmative action. And I think we can't lose sight of racial inequality in American society. But certainly legally, affirmative action meets a compelling state interest, and that is to have a diverse learning environment. And since that Bakke decision, social scientists really got to work and said, well, let's try to understand what exactly is the impact of a diverse learning environment, and did a lot of studies looking at interracial interactions in college, the shift from someone's racial environment in high school to college, and found a whole host of positive outcomes, including, increased civic participation, cognitive capacity, of course, racial attitudes. So we know now that this really does have an important impact. And we know a lot more than we did, in 1978 when the court accepted that justification.
Understanding that Bethany has made very clear that we're talking about 2 different issues, both Harvard's admission policies and affirmative action. Let me just put these facts out. In 2018, when we were looking at the stats at that point for Harvard, they had 40,000 applicants. They accepted 2,000 and 1,600 enrolled. However, 4,000 of those 40,000 originally had perfect SAT scores. So if they merely considered no other factor, that means no other factor, which they don't do with any applicant, then you could fill the class with just people with perfect SAT scores. That is not what any college does. They consider other factors. And so when we talk about the question of considering race as a factor, it can be a factor with people who are potential applicants of color. Now, Paul, your concern is that we're at a time in this country where we are actually debating systemic racism and whether it exists, but at the same time, having demonstrated on campuses and in industry and the rest of America, that there is a value in having diverse populations. So this case, the court taking this case at this moment is a little disturbing to you.
It is, and let me respond specifically to the Asian American take on this. I'm an Asian American who was admitted to Harvard for graduate school many years ago, and I think I was admitted because of affirmative action. It was not because I had perfect GRE scores by any means. I was far from it. And I think I benefited from it. I think Asian Americans should understand the value of how they have benefited from affirmative action. So that, not that I'm any great example of this, but I am somebody who was assisted by affirmative action. Asian Americans have over the years been done so. And secondly, if we look at the situation for Asian Americans, we should say not only is it Asian Americans who may be discriminated against, and perhaps they are, but who is taking those seats that should go to Asian Americans in terms of the larger desire of getting more diversity. And that forces us to look at the situation of things there's a disparity in the admissions process, but it's a disparity that is in favor of white students. And if you look at the issue of legacies and you look at the issue of things like sports admission, people are admitted because of sports and so forth, those things overwhelmingly serve the interests of white students. And it's not really Black and Latino and Indigenous students that's stealing seats from Asian Americans by any means. If there's any disparity in terms of admissions, it's in terms of white students who are being helped by a system that largely serves them, with a third of all admissions being done through legacies and 70% of all those legacies falling to white students. That's the culprit, I think, that we have to consider here, that's standing in the way of the diversity that we want to see.
To be clear, when we talk about legacies, we're talking about, as you've made the point, a third, if just Harvard specifically, a third of those folks who are accepted at Harvard are from legacies, meaning people who graduated, or they're related to people who graduated from the college. They are star athletes. They are maybe related to faculty and staff. This is long traditional that you give consideration to certain special people, and overwhelmingly those numbers are white kids. That's just not a number that includes high numbers of students of color. Here's the other thing, Bethany. I hate to keep throwing these stats out, but when California and Michigan removed their affirmative action program in the middle of all kinds of stuff, the drop rate from Black and brown students was 45%. That's undeniable. That's the result.
Right.
Yeah.
That's right. And that's absolutely the result. That's what universities, school systems have found when race conscious admissions is not allowed, and nobody benefits. Black students, Latinx students, Asian students, white students, nobody benefits. Because when we talk about diversity as a compelling interest, it's actually kind of confounding to me how the Supreme Court is going to be able to say that it's not a compelling interest, right? When we talk about all of the different studies that Natasha and Paul have mentioned, and we understand how kids from K to 12 and into colleges are benefiting from the diverse environments that we live in, and because that's the world that we live in, it's confusing to me how the Supreme Court is going to be able to overturn 40 years of precedent and say that diversity is not compelling.
However, Jessica, I just want to make this point. This court has overturned precedent. This court has overturned precedent on behalf of Edward Bloom's group. His Students for Fair Admission are behind the Harvard challenges, the University of North Carolina at Chapel Hill challenges, and was behind a voting rights challenge in which he was effective, or his group, in getting a significant part of the Voting Rights Act struck down. So here we are. If it goes away, what are we looking at, Jessica?
So the district court in the Harvard case really looked at what would happen if you don't have affirmative action. And the district court found that, when we're talking about African-American population right now, or when they looked at it, it said at 14%. It was estimated that would drop down to 6%. If we're looking at the Hispanic or Latinx population, again, it was at 14%, and it would drop down to about 9%. And it was estimated that over a period of 4 years, nearly 1,000 African American or Hispanic students would disappear from these campuses. So when we're looking at striking down affirmative action, we really are looking at kind of destroying one sector or one aspect of diversity that is on a campus. And the argument is being made by Edward Bloom and the positions that were before the Supreme Court that if the Brown decision was correct and that we can have segregation, arguably, then we also can have affirmative action, which would also look at race. And therefore, under the 14th Amendment and under Title VI, we can't use race at all because you do create like special classes of American citizens. And that's the thing that Brown was seeking to destroy. I absolutely don't agree with that statement, but they're trying to turn around the precedent that was favorable or help support advancement for Black and Brown citizens against us now.
Correct me if I'm wrong, but in the 54 decision, the court, in its opinion, in its ruling, said, discussed the damage being done by segregation. Right? So race had to be a factor. I'm just saying.
That's right. And I think when we're looking at the Harvard case and kind of where we think that the Supreme Court is going to go, I think it's important to note Alito's dissent in the second Fisher case, which really did focus on the fact that he didn't like affirmative action because he felt as though it discriminated against Asian Americans. And now you have this suit. Again, you have a conservative majority in front of the Supreme Court, and the question of whether or not you're going to strike down affirmative action. And Edward Bloom is using Asian American students to get us there. So it may just be that now you have a court that's more willing to use the smokescreen as the thing that's going to strike down this program.
What keeps you up at night, Natasha, thinking about this going away? Though you've said you don't think that higher education, institutions of higher education could try to figure out a way to survive of the blow of removal of affirmative action.
Well, I think we have to wait and see what happens. I'm sort of not assuming it's a done deal. I think, let's see. It's hard. I think like Bethany, I think I'm kind of baffled. Like, how will they justify a decision given all of the evidence that we have? I think that universities will pivot as much as they can. Perhaps they will do away with some of these policies that Paul has mentioned, legacy admissions, reduce athletic recruiting. There's all kinds of things like geographic diversity. They want somebody from every state, and guess where people of color live? We live on the coast. And so there are all of these things. I think moving away from the SAT is something that Harvard and a lot of colleges are doing. I think that will help. So I think all of these will attenuate the impact if affirmative action ends. And again, I don't think we know, but whether it will or not. But if it does, I think some of these things are positive moves and they will attenuate the impact. But I still think, if we look at, University of California, it's been almost 25 years since the state of California voted to end affirmative action. And, the impact it's not so good. And it's, and there's some new data that suggests it even is impacting wage differentials. And so, I don't think we should soften what the impact will be. But at the same time, I think universities will also be creative in trying to figure out ways to be as inclusive as possible while following the law.
Well, here's the thing. We're moving toward 2050, where this country is going to have what some have described as majority-minority population, meaning there will be more people of color than there will be white people. This seems to be a very retro way to go, given what we're looking at demographically. And it's happening now, just in case people are thinking, well, it's way down the road. All kids in kindergarten, they're already more diverse kids, more kids of color than white kids in kindergarten at that level, at that age. So it's here. So Bethany, I see you nodding your head. It's like, what to say about it? By the way, I should mention that the court did ask the Biden administration to weigh in. Of course, the Biden administration said we support affirmative action. I don't know how to interpret that. And some other industries have said, hey, we think this is valuable. So it's, to Natasha's point, I guess, it is a little bit unclear. But yet, they asked to do the ruling. I mean, they don't take every case. So that to me says there's an overriding, something going on there, Bethany.
I mean, just everything that you just described is shows how the idea that the court would say diversity is not a compelling interest doesn't comport with reality, right? And in the 2003 Grutter decision, when the court kind of tried to predict the future and say 25 years from now, maybe we won't need this affirmative action policy, right? And said, maybe we'll be in a world where we live in this kind of ideal, ideal situation where racism is not a thing. And everything we've seen during the pandemic has shown us that's not the case. Now, what is it, almost like 20 or so years later, right? And that's the kind of interesting thing about the way SFFA is trying to make their arguments, right? One of the kind of points that they raise is these universities are seeking to keep these affirmative action policies indefinitely, right? They're kind of like, shouldn't we be working towards that 25-year mark in 2028 where we won't need affirmative action? And that's just not the reality, especially given the world that we live in.
Well, we're going to leave it there at the end of our broadcast. We got more to say about it, but I want to thank all of you for joining us. And now stay with us as we continue our conversation on our digital platforms, Facebook and YouTube. I'm Callie Crossley, host of Under the Radar 89.7. We're on Facebook and YouTube with our post show, continuing our discussion on Harvard admissions and affirmative action. Is there any one thing that each of you would like the viewers to keep in mind as we're thinking about the Supreme Court taking on hearing these cases? There's something that we've not touched on that we just need to just keep in front of mind as we're evaluating it. I'll start with you, Jessica.
Yeah, I would just echo what Natasha and Bethany have emphasized, in that it's not certain that the court will actually strike down affirmative action. Rather, there are two questions that are before the court. One is obviously striking down affirmative action, but the second is what it means for a university to consider or have available a race-neutral alternative. The district courts looked at this in terms of Harvard getting rid of legacy tips or giving more of its tips to geographic or socioeconomic status. And that would actually create a diversity, but you get rid of some of the benefits and some of the academic excellence, et cetera, that Harvard right now demonstrates. But another question before the court is whether or not that is sufficient, the fact that you do have something available, even if it destroys Harvard, whether or not you can actually use that, and therefore you can't consider race because you do have this other thing available.
Mm-hmm. Paul?
Well, I'm more worried about what the potential legacy of all of this fighting is going to be. Because as you point out, as the country becomes more non-white, the question is are we going to embrace it, or is there going to be resistance to it? And we're seeing resistance to it time and time again. And that's why the Harvard case and all these things are so important to me. That's what keeps me up at night. Here we're having this transformation in terms of society, and I think it's a positive one. The diversity is a strength. And yet you have lots of forces who are going to oppose it. And think about in the education sphere. There's a significant movement about not even teaching about race in our schools. Even talking about race is considered to be verboten to a lot of people. So here we're talking about a time which all the people here have made wonderful arguments and reasons why we should embrace the diversity and why it's a strength and why it's obvious. And yet there's a powerful forces out there opposed to everything that any of us have said here today. And their power is reaching not only the halls of Congress and so forth, but the Supreme Court of the United States. And the presidency of the United States just recently. That's a significant factor in terms of what is happening in this country today. And that is worrisome to me in all these respects. It's a worrisome world that I'm seeing. And unfortunately, this transformation you're seeing is facing resistance even today.
Natasha.
So one thing that we haven't talked about that I hear a lot from kind of skeptics of affirmative action is that, well, what about class? Like, shouldn't we be just paying attention to class, and that's the, what colleges should really be doing? And my response to that is, I don't think we need to do either or, right? I definitely think that colleges should also be looking at, and that they do, and they should be doing more of looking at class. Places like Harvard in particular, selective colleges in general, working class and poor students are pretty severely underrepresented. First generation, those who are the first in their family to go to college, are pretty underrepresented. And so I think even middle class students on some of these colleges are underrepresented. So I definitely think they need to do a better job with class, but I think we need to understand there is a difference between class and race, and that, the impact of race on a person's lived experience is not just about class, right? You can be, a Black professional, and you're more likely to be, the first or second generation out of the working class than if you are a white professional, because of the kind of legacy of racial exclusion. And so, less likely to have those, inherited resources to buy your first home, to pay for a child to go to private school. And so, and then even when we look among working class African Americans and working class whites, African Americans are more likely to live in neighborhoods of concentrated poverty, and their children are attending lower quality schools. So there is a difference between class and race. And I think, one doesn't preclude the other. It's not like if we take into consideration race, we can't do more about class, or if we think about class, we can't think about race. So I just wanted to put that out there.
And, all they have to do is look at those couples in very upscale communities that had to get their white friends to show the house for them so they'll get a correct assessment of the value of their house, because they
Yeah.
wouldn't get it if they were there. And that
Absolutely.
says it all. They can afford to be there, they can afford to sell it, but they can't get what is rightly theirs. Or the cardiac patients with full insurance who are, routed to general instead of cardiac therapy. But we could go on and on. As
Absolutely.
Kelly
And
said.
we can, that list is very long. I
Yes.
think that's the point.
Yes. Bethany, what do you want to make sure that people keep in front of mind as they're thinking about this?
I would highlight this systemic plan to target policies that are focused on racial equity, right? That's what's happening. That's what's happening across all of these universities. That's what's happening with the Voting Rights Act, and these billionaires are banking these lawsuits using civil rights and anti-discrimination language. That's what's most infuriating to me. We intervened recently in the Boston Exam School case on behalf of a group of multiracial organizations and families, and including Asian Americans, saying that we need to be on the right side of history here when we talk about racial equity. And that's also what's frustrating to me in terms of how Asian Americans are being used.
The next question is, there's been much discussion, and President Biden is moving toward nominating or fulfilling his promise to nominate a Black woman to the court. We know should she get through all of the process, that will not change the balance in terms of power on the court. So it'll still be a conservative majority. But many of you have suggested that just the power of a woman, a Black woman, being able to articulate arguments coming from her lived experience and her expertise could be valuable in the back, and that in all the places we don't see where they have discussion, assuming they continue to have discussion, that this is important. Jessica, how do you weigh that?
I think that's a valid argument or a valid consideration. To be able to share your lived-in experience with your colleagues and be able to better articulate why these programs are important may sway some justices. You do have these dissenting opinions in the last affirmative action case from some of the same justices that are on the bench now. But say, for instance, Chief Justice Robert has not in the past wanted to strike down established law. And you may be able to sway, or maybe not, I don't really know, someone like Gorsuch, who did give us the Bostic decision where title was said to include discrimination against sexual orientation on the basis of sexual orientation. So there may be some room in order to have a conversation and be able to say why a program like this is important, especially for a Supreme Court that has shown that it's more policy oriented than just strictly adhering to the law.
Anybody else feel that there may be some value in that we wouldn't know, of course, it'd be happening behind the scenes?
Yeah, I'd love to weigh in on this because, we've been talking about the value of diversity for higher education. And, all the research suggests that a Black woman on the court is going to make a difference. Diverse organizations seem to make better decisions, take more points of view into account. Certainly, she's likely to have a lived experience that is different from the lived experience of the other justices right now. And so, if we believe that research, which I do, and I think that it will bring a unique voice to the court that will be have a positive impact. And, so I really see this as an asset, right? There are, I'm sure there are plenty, not plenty, but there are more than one, certainly, people who are qualified to serve on the U.S. Supreme Court, but adding diversity is an asset and a plus. So I think it's really fantastic that President Biden has, said that he will fulfill this promise.
I didn't mean to suggest that there wasn't an inherent value. I meant, could there be more to the discussion behind the scenes that might be persuasive in cases like this? That's what I meant.
Yeah,
Yeah,
absolutely.
that's what I meant. Anybody else?
To me, the concern is that I had hoped that by 2022, we'd reach the world that agrees with what Natasha just said about and you had said about the value of having this woman with her experience on the Supreme Court finally. But here's a sign of our times. There's a very positive argument to be made for it, but there's going to be a very strong negative response to even her appointment to the Supreme Court. That's where we are in society today. We had thought that we had progressed to a point where the notion of not having a woman on the Supreme Court, a woman of color and a Black woman on the Supreme Court is something that we all would say, of course, that's something that we should have here in 2020, finally, after all these years. But there's as much strong resistance to that as there is positive force in favor of it. And that's a sad situation, I think, about the racial discussion in the United States today. I think it's part of what Bethany says. It's a resistance to any notion of equity based upon race and the desire to get inclusion, equity within our society reflected in all of its elements is something that there's such strong resistance to. And unfortunately, there isn't this sort of consensus around what Natasha and you and Jessica and Bethany have said about the desirability of having this representation in the Supreme Courts or in our educational halls, et cetera. That to me is the dismaying part.
Well, Paul, if I may put a button on this conversation to say that I think what's driving that is that there continues to be, sadly, a denigration of persons of color by saying they're not qualified to do this work. And so if you can't get to understanding that there are brilliant people who are qualified to do all of this work, then you're up against that all the time. But anyway, we're going to leave it there right now. You'll be back to discuss this, I'm sure, and I appreciate you all having this conversation with me. Thank you.